My name is Dr. Alex Deegan, and I'm a senior lecturer in the School of Law here at the Queensland University of Technology. I'm the coordinator of the QUT Global Law, Science and Technology Seminar Series, which brings together national and international speakers who explore the personal, societal, and governance dimensions of solving real-world problems, which are influenced by and through the interaction of science, technology, and the law. I'd like to officially welcome you all to today's seminar. It's very pleasing to see participants from both the profession and universities in Australia and around the world. This fourth seminar of our series in 2021 is A Scholar's Journey, or how someone who struggles with his iPhone is the world's most read and cited FinTech scholar, presented by Scientific Professor Ross Buckley from the University of New South Wales. You can find an abstract for the seminar in the information for this event. The format for the seminar will be as follows. Professor Buckley will speak for about 30 or 40 minutes, and then this will be followed by a Q&A session. I'm going to turn it over now to Associate Professor Mark Burden to introduce Professor Buckley more fully. Mark is an Associate Professor here at the QUT Law School. He's co-convener of the Regulating Digital Futures Group with Associate Professor Anna Huggins, an initiative of the Law School, which is affiliated with QUT's Digital Media Research Centre. The group examines the new forms of coded legal and regulatory authority that are unfolding in data infrastructures and organisational governance systems. Mark is also going to be chairing the Q&A for us. So thank you, Mark.
Many thanks, Alex, and it's an absolute pleasure to be able to have Ross along today. Ross Buckley is the Kingwood and Mallison's Professor of Disruptive Innovation at UNSW Law. His research interests regard the use of FinTech, RegTech, and the societal issues that arise from data and its algorithmic analysis. His work is recognized throughout the world. He is SSRN's highest downloaded scholar on FinTech and RegTech, and he's conducted previous research projects in Australia, Hong Kong, and Qatar. Ross has consulted with numerous governments in Southeast Asia and Africa, and has also researched the delivery of mobile financial services in developing countries with the UN Capital Development Fund. He currently chairs ASIC's Digital Finance Advisory Panel. In 2020, he was awarded an ARC Laureate Fellowship worth $2.6 million. And just for those in the audience who are outside of academia, the Laureate Fellowship is the very top of the Australian research tree. It's awarded only to eminent scholars that demonstrate a sustained career of the highest quality research in areas of national importance and international significance. And so let's hear from Ross on his journey from iPhone struggles to how he's become the world's most cited scholar in FinTech and RegTech. Ross, over to you.
Okay, thank you. Thank you very much, Mark. What I want to do today basically is look at the last 8 years of my career with two purposes in mind. One is to explain some of the things I've been working on because some of the substance might be of interest. Also to try and extract some lessons generally for legal scholars because it strikes me, I've been a bit lucky and there are some lessons to be learned from that luck, lessons of sort of general application, at least I hope there are. So now the first way is going to be to see whether I can share my screen successfully. Okay. Now, okay. Okay, that looks all right. You can see that, Mark? Yeah, okay, good. But, so back in the day before, my old field was international financial regulation, systemic financial regulation. I started researching the debt crisis in 1982. In 2013, I'd been doing that for a long time. There was a young research fellow who needed a job at UNSW, and it's a long story, but there was a research centre that I knew would give me a grant. And so I applied for a grant. He had an idea on mobile money, and I really just did it because he needed a job, and I knew I could get a grant. And mobile money is that M-Pesa story in Kenya, where Vodafone started to take real money and put it in electronic form on telephones. And it has all sorts of financial inclusion benefits. And we did some good research on it, on how do you protect the float in the event of bankruptcy? How do you protect consumers but still make the thing profitable. It's a big problem in a lot of poor countries that people can't get financial services, and mobile money is one answer to that. And there are a lot of regulatory questions about it, and we have helped to solve some of them, I think. But so that's sort of where this latest iteration of my journey began, with mobile money in developing countries. Then in 2015, looking back, that was sort of the pivotal year. If you're a boring person like me, you listen to Sunday Extra on ABC Radio with Julian Morrow, and he has the year that made me section. It's a very interesting Sunday morning radio, because he's the most inarticulate radio presenter you'd ever meet. I don't know why he went into radio, but he's a lovely person. Anyway, that year I won a big ARC linkage grant with $500,000 in funding from the UN attached. But more significantly than the grant, which was on mobile money, that was my second big grant on mobile money, but more significantly, Doug Arner, a colleague of mine in Hong Kong, with a very young Janos Barbaros at the time, invited me on to a paper. And I really think Doug did that because I'd done some favours for him. He'd had a difficult couple of years with the health of some of his family members, and I'd covered for him a few times. So he wanted me on the paper. I don't honestly think I had enough contribution to that paper to justify being on it, but he wouldn't hear that I wouldn't be on it, so I was on it. And that paper changed everything. And that is the one part of the lesson that I can't really work out why, so I can't help you. I can't really tell you how to create a paper like that. But that thing has downloaded more than 20,000 times off SSRN. It still downloads more than the stuff we've written more recently. And what it did was it went back 150 years and reconceptualized the evolution of FinTech. So FinTech is the application of technology to finance. Everybody thinks it's this big new thing. We took it back to the laying of the transatlantic telegraph cable in 1867 and basically looked at the evolution of the interaction of technology and finance for 150 years, when we could have taken it back 2,000 years if we wanted to. So it took a historical perspective to something that people thought was new. And as I said, I'm not sure why, but that has just become an extremely popular paper, and the framework is now sort of accepted. And I think there's some sort of spin-off effects for all our subsequent scholarship from that paper, really. Sort of maybe it's given us an audience or something like that. The next year we did one on financial regulation. We looked at how RegTech, which is the application of technology to regulation, really should allow regulation in much closer to present time. And it's interesting. These papers were very forward-looking in that is still coming. ASIC now is letting tenders for the development of natural language processing software to scan recordings of traders and bankers that they have access to, or to scan documents, looking for the sorts of statements that would be problematic from a financial regulatory point of view. So we talked about the potential to do this 5 years ago. Now ASIC is doing it, is trying to move its regulation to, based on the data that's available, to something that's very close to real time. 2017, Janos moves on, and Dirk Setcher, a German from the University of Luxembourg, joined us. And we wrote 2017 was a very big year. We wrote 4 big papers. And the biggest one in terms of themes, if you're interested in the substance, is the rise of data-driven finance. In a nutshell, banking has historically been conceived of as a relational business, and your bank knows more about you than anybody else. So they use that information, they treat it as their data historically, and they use it to price credit to you. But the bottom line is the party who knows the most about you can price credit and can price risk the most accurately. So they win. Historically, they were your bank, but they're not necessarily your bank anymore. You know, Woolworths has spun off something called Quantium, which is a data subsidiary of Woolworths, because if you've got a frequent shopper card, Woolworths knows a tremendous amount about you. You know, they can predict your life expectancy based on what you eat, to the point that it undermines the very basis of the insurance industry. Data is incredibly powerful, and we're only starting to see it. And the Australian banks are very, very slow to understand this. But the rise of data-driven finance is absolutely an existential threat to our financial system, to our banks, and it all starts from the idea that the party who has the best data and the best analysis of that data wins, and that party traditionally these days isn't the bank anymore. It's Google or Apple or Microsoft or Facebook or Woolworths or Coles, or all of these entities have better data about you than your bank does. We wrote a big paper about initial coin offerings, which are a tokenized fundraising methodology. We wrote a big paper about regulatory sandboxes, and we analysed liabilities under blockchain, so distributed ledgers. And part of what a lot of these things had a lot of impact because of the topicality of them. And that's something where my research has really changed in the last 8 years. Going back, I would never have published anything as rough as our paper on initial coin offerings. We threw together a group of 1,000 of these white papers, these offering documents. We had some RAs analysing them. We got the paper into the market of ideas remarkably quickly when it was really rough. But because it was out there on SSRN, the central banks were reading it. I remember one Friday night, I had to sit up until midnight. I was grumpy. It was cold in August in Sydney. And the US Fed had asked us to join them on a call, and they said they'd ask a couple more central banks onto the call. So I was sort of grumpy, but by the time the central banks had introduced themselves, we had 24. We had basically 24 of the world's largest central banks on this call wanting to talk about initial coin offerings. It wasn't that our insights were particularly brilliant. It was just that there was nothing else in the space. In a couple of years' time, in 2019, when Libra, Facebook proposed Libra as a stable coin, which it still hasn't implemented, but when the proposal came out, we had a 10,000 word article written on it in 12 days. I remember the Wired, the American, whatever Wired is, I suppose it's a sort of inside story, sort of, internet magazine. It interviewed me about it, and the journalist said, before he started the interview, he said, "Look, before I start recording, can I ask you a personal question?" And I said, "Yeah, what?" And he said, "How did you guys write this in 9 days?" And I laughed, and I said, "Well, we span 3 time zones, so we can actually write for 21. This is Dirk Setcher in Germany, Douglas in Hong Kong, and me here. We can write for 21 out of the 24 hours." And he said, "Oh, okay, that makes sense." The point of the story is that, again, that article had tremendous impact. It was because it was the first analysis out there of something that was profoundly new. It wasn't because I was so wonderful. I would not ever have published anything that was so rough 10 years ago. But what I've learned is what matters is being first to market. Ultimately that article came out in a really good journal, but between when it went up on SSRN and when it went into the journal, it got revised a lot. And it took another 2 years. It only appeared in print this year, so it took another 2 years to appear in print. I don't actually think the journals are very important anymore, to be honest. The journals think they are, but I don't think almost anybody who matters reads what I write in journal form. Journals are there for promotion applications or research grant applications or things like that. But I think as scholars, when I began my career, we read each other in journals. Now I think we read each other off SSRN. And what really matters is who gets first to SSRN. And the old things I used to really worry about, like elegant sentences and, no typos and everything, I just don't think matter in that world anymore. They perhaps still matter in the journals, but the journals are coming along 2 years behind. I mean, the Libra article illustrates that beautifully in the sense that it came out in the Oxford Journal this year, and the journal seemed very proud to publish it and didn't seem at all bothered by the fact that Libra has disappeared. It's now completely reconfigured by Facebook. It's called DM, as in seize the day, not Libra, and its whole structure is different. But the Oxford Journal is still happy to publish an article that basically largely out of date. It's sort of funny. There's these, where the world communicates and this parallel scholarly thing that is so far behind this modern rate of change. Interesting. Next year, just going through in a timeline sense, we did something. This is the other thing we do, and the other thing that I think is could be useful for those of you who have the opportunity to do it. We do a lot of work for agencies. So one that we do a lot of work for is the Alliance for Financial Inclusion, which is a gathering of 100 of the poorest countries' central banks. We also do quite a lot for the Asian Development Bank. We've done work in Middle East and North Africa for the German Development Agency. And what these agencies have in common is they're advising poor countries. So we write reports for them. They pay us very small, tiny amounts of money to do it, but we don't do it for the money. We do it because it's wonderful for impact. And the other way our world is, as scholars, is changing is research grants and things are very focused on impact. Modern universities are very focused on impact. The ERA quality assessment process in the UK began this initially, to my knowledge, but ours seems to have moved into it. So now quality research assessment processes are focused on what impact you have. That's a big problem for us in law as a general rule. I sit on a number of university-wide committees in my university, and it's essentially a bit like yours, I imagine, an engineering science university. And the impact that the engineers and the scientists can point to, indisputably, is extraordinary. You know, I've sat on promotion application committees for professors in medicine where, you know, the application begins, my research has saved the lives of 320,000 people, full stop. That's the first line. So that's what we're competing against in law. And so working for people like the Alliance for Financial Inclusion, we did this project for them, which was, how does a country get its regulatory framework in place to support financial inclusion, to support the electronic delivery of financial services to its poor people and its rurally remote people. And you can see it on the screen. We came up with 4 pillars, which are largely a rip-off of what India's done with Aadhaar, a bit of a variation on the Indian system. And so we write sort of a simple report, but then what happens is that report gets implemented. And so when we're next seeking research funding or whatever, we can actually point to 26 countries have implemented our recommendations. Here are the 26 countries, here are their laws, this is what they've done. For lawyers to be able to do that is sort of game changing, but it's just because we are in a research funding context, we're competing with people who can do that every day. That's their world. So, you know, the way we get there is by doing what is effectively charitable work for agencies that, if we've got it right, hopefully makes a difference. So it's satisfying, but it feeds into the research game very well. 2019 is the Regulating Libra piece that I've already spoken about, where we, you know, 9 days and it was up on SSRN. Obviously, to do that, it's got to be in an area that you know very well. And also there needs to be more than one of you. And I will return to that, the advantages of multiple authored pieces. The other one we did in 2019 was a piece on tech risk. And this is sort of typical of what we do. We're all the time trying to be 5 years ahead, trying to predict where things are going in 5 years' time. As I say to the firms who sponsor my chair, KPMG and KWM, I've got the best job in the world because I can stand up and spout off at our regular seminars for their clients. And if I'm wrong, nobody's going to remember in 5 years' time. And if I'm right, hopefully I'm still around and I can remind everybody that I was right. But that's where we're working. So we came up with this term tech risk, and we were sort of helped by Westpac's horrible story of allowing transfer of money to the Philippines to pay for the formulation of live pedophilic videos of using young children. So that's the sort of thing we like to do, to try and predict the future and try to be saying to regulators, where is this going? What should you be doing about it now? And it's frankly an easier space to research in than what has happened 10 years ago. Because by definition, there's not very much competition. There's not many people working in the space. It's very, I think forward-looking is a lot easier than backwards-looking stuff. Last year, we did 3 major papers. One on digital finance platforms, which is the other big future trend I would point out. One is the rise of data-driven finance, which will continue for the next 20 years, and which very likely in 20 years' time with data-driven finance, you'll have people will be banking with Google, or they'll be banking with Facebook. There'll be a bank in behind, but you won't even be aware of who the bank is. People won't care. They'll just be banking with Apple, you know, and the profits will all end up in Google or Apple or Facebook, because they're the party with the data. They can make the best decisions, and the banks will be relegated to sort of a white label function in the background. The other big trend that's happening right across our economy is platforms. And Australia has largely missed this one. The only platform I can really think of that's significant in Australia is Qantas, funnily enough. Because if you think about it, Qantas, the profitable part of Qantas even before COVID was frequent flyer program, not flying people. And the frequent flyer program has its own currency, points, a bit like e-money, and it connects customers with suppliers. So suppliers of hotel rooms, suppliers of Dyson vacuum cleaners, suppliers of all sorts of white goods, you know, people use their points to buy these things. So, excuse me, Qantas sits in the middle as this platform. The same way Amazon is a platform which mostly connects customers to suppliers that are not Amazon. Some of the supply on Amazon is from Amazon, but most of it is other suppliers, and Amazon sits in the middle. So this platformization thing is really big overseas, far less developed here, and I'm not sure why, but extremely developed within finance. And so, for instance, in America, there's far more money invested in mutual funds than there is in the banking sector. Americans simply have a lot more of their savings in funds than they have in banks. The whole of the US funds management industry runs on Aladdin, which is a platform developed by BlackRock. From our point of view as financial regulators, it's extraordinarily problematic. If Aladdin goes down, the funds industry loses its front end and its back end. What I mean by that, it loses its ability to onboard customers, its ability to make decisions as to investments, its ability to settle those investments. Everything works through this one massive platform. China, a very similar story. Ant Financial is the dominant platform in China. You know, it began as a Alipay attached to Alibaba, a bit like PayPal exactly like PayPal for Amazon. Alipay developed into Ant Financial, went from payments to money market fund to now sort of everything incredibly quickly. And what you see is the Chinese government now squashing it down. They've already diagnosed or sort of designated it as a systemically important financial institution, which attracts all sorts of extra regulatory burdens onto it. But now, they, ever since they intervened in the IPO of Ant Financial late last year, they have been clearly trying to put the entity back in the box because they're clearly worried about the systemic implications of it. The US hasn't done that with Aladdin, and it's not yet doing it with other financial platforms. The problem from a regulatory point of view is that platforms typically won't trigger, they don't provide the financial service. They connect the customer with the provider. So they don't trigger the triggers that are there to require registration as a bank or, you know, taking out of a financial services license. So they're a different way of organizing things. So they don't fall subject to the traditional forms of regulation, but they absolutely grow so fast that they become systemically significant, and they need to be regulated, you know. And my favorite example of the scope or the potential for that, back in about 2014, Ant Financial noticed that people were, or Alipay as it was, noticed that people were leaving money in their accounts. When they'd buy something from Alibaba, they wouldn't take the money out. They'd leave it in and use it to buy the next thing. So they set up a little money market fund called Yui Bao to allow people to invest these little bits of money. Within 9 months, it was the 4th largest money market fund in the world. the three larger ones had all been set up in the US in the aftermath of World War II. So they'd had 60-something years to grow to the size that this one grew to in 9 months. The People's Bank, the central bank, put the brakes on it for about 6 months and stopped it. But then when they let it grow again, within another 6 months, it was the biggest in the world. So that's the sort of scope of change we're dealing with here. It's an enormous challenge for regulators. It's a huge, huge problem because the world can change that fast. Now, literally, a regulator can go to sleep one night and wake up 1 year later, and something like this money market fund has gone from not being existent to being one of the 4 biggest in the world, with all sorts of systemic implications. A couple of other papers on decentralized finance and COVID-19 and central bank digital currencies, because last year everybody had to write something on COVID-19 in finance. And this year we've done regulating AI, we've done something on AI in finance, which is a huge challenge, something on China's central bank digital currency, and more on sovereign digital currencies. So central bank digital currencies are coming, by the way. Australia, the Reserve Bank is pioneering one, or exploring one more accurately, for wholesale, not retail. But I think we'll be forced to move because China will eventually release its one for offshore use. Other countries will follow. So the idea of a central bank digital currency is it's an electronic currency that is the currency of the country that operates the way a cryptocurrency would operate, but it's issued by the central bank, not by Facebook or by the creators of cryptocurrency. So the very nature of the money, we've got used to cash for centuries. Cash is in decline. It's in rapid decline in Australia as a result of COVID, but before COVID, the Central Bank of Sweden had worked out cash would go out of use in Sweden by 2023 or 2024. Already 70% of branches of banks in Sweden don't have cash in them. So we're again moving somewhere brand new, where cash is going out of use. We at the moment in Australia, it's being replaced by Visa and MasterCard, whatever, but they're very expensive and have all sorts of problems. And the Central Bank of Sweden decided it wouldn't trust Visa and MasterCard to provide the only means of exchange to poor people, to elderly people, to people in remote areas. So the central bank basically said a couple of years ago, we have to get into this space. The Chinese central bank is leading the world in this. It's pioneering the thing in 7 different areas, piloting it in 7 different areas in China. China's doing it. And when China does it, eventually the China-aligned Belt and Road countries will come on board. And so you're going to have, what China is doing is building an alternative currency block to the US dollar, basically, because it doesn't like the way the institutions of Western finance have excluded it for so long. So this, again, just the speed of change is quite remarkable. Within 10 years, we will have currency on our phone that will be central bank money. And the only central bank money you and I have at the moment is cash. When QUT pays your salary, that's not central bank money, that's commercial bank money from their account to your account. It's just book entries in an account. This will actually probably will look something like individuals having accounts with the central bank, probably intermediated by commercial banks, but it's really complicated. It's a really different world and it's coming. We're not going to get away from it, whether we want it or not. So I began by saying, what are the sort of lessons of broader application? One of them, I think, is that luck matters. I've been lucky in some of these things, without question. I think doing good deeds can matter. I think I got on to the mobile money thing because I wanted to help a young fellow who seemed nice, who needed a job. And I got onto Doug's paper because I'd been helping Doug with some other stuff. Another lesson I think that's relevant to all of you, which is perhaps less relevant, or maybe not right now in COVID. Before I started to work with international co-authors, my impact had been incredibly restricted because I was here. I completely underestimated how important it is making presentations of your ideas. And if we set COVID aside for a minute, it's really difficult to do that. for years in Australia, I'd been invited to events in Washington, DC, or New York, or Toronto, or Brussels, or wherever. And they were typically 1 day, 1.5 day events. It's really hard work to go to those places for a day. It's really important. And I didn't take up most of those invites because I was heavily involved with raising my kids. But I really underestimated how important they are in terms of your ideas having impact. So in that sense, for the last sort of 4 years, I've been working with Dirk, who is based in Germany and Luxembourg, and Doug, who's based in Hong Kong and who flies far more often than is healthy for any person, at least before the pandemic. So between and I don't fly much, but between the three of us, we were able to accept a lot of invitations. And a lot of those invitations just put our ideas on the map in a way that I would never have been able to do by myself. Another element of that is that I think, and this is something that I think legal scholars don't do much of, and really is where we have a huge amount to learn. I think multiple authored publications have far greater impact. And a few years ago, I read an article, unfortunately I didn't keep it and I haven't been able to find it again, but it was analysis of citation rates for scholarship. I don't think in law, I think across all sorts of fields. And the conclusion was that pieces of scholarship with more authors have more citations, but particularly if the authors are geographically spread out. So if there's 4 authors on a piece of work, they're all in the same city, it didn't make very much difference how much impact that paper got. But if the 4 authors were spread in 4 different cities, it had more impact. If they were spread out to 4 different corners of the world, it had demonstrably more impact. I think I've worked out the reason. I don't know if the people who wrote this article knew the reason, because I think they were just crunching data. But I think from my lived experience, the reason is that if you're spread out around the world, you can accept a lot of the invitations that come to present. So, you know, Dirk in Europe is in Dusseldorf in normal times, or even frankly now, because travel is permitted there. He can get anywhere in the middle of the day and home to present and home that night to see his kids. And so, you know, he does all of our presenting at the Bank for International Settlements in Basel, who we speak to a lot. And, you know, I get on calls with them, but I don't have to go to Switzerland. Dirk goes to Switzerland. It makes a really huge difference. The other thing, and I've put in italics there, provided you work well together. I've certainly co-authored things in the past that took me a lot longer to write than they would have if I'd written them myself. And I'm sure most of you have had that experience. So it's a matter of finding the right authors, which I appreciate. It's a bit of a counsel of perfection. But Doug, Dirk and I are very different sort of personalities. We sort of work together well. We have different abilities and different sorts of energies. And increasingly, we're moving beyond the 3 of us to 4 or 5 authors on an article. So we have young postdocs on the articles with us. And writing big legal articles is just hard work. It becomes a lot easier when you have 4 or 5 people on it. And it's sort of strange, I think, that our discipline still prides itself on sole authored work, because there isn't any real reason for it. Most divisions in the university don't do it, right? If you go knock on the door of the scientists or the engineers in QUT, you won't find many people publishing stuff by themselves. Basically, there's nothing new about the way I'm running at the moment. I'm just running a small lab the way scientists have run them for forever. You know, I've got a few postdocs, I've got a few research assistants, and I'm running a lab, and I'm running it with 2 experienced people overseas who we work well together with. The other thing I'd say is you've got to come up with a way of working that works for you. So Dan Orey used to be at Oxford, is now at Cornell. I was walking through Oxford with him just after my initial coin offering paper came out. And he looked at me, he said, the title of that paper, that was yours, wasn't it? And I said, yep, that's right, that was mine. He said, yeah, work that out. He said, but he said, I read it really carefully and I was looking for 3 voices and I couldn't find 3 voices. He said, I could only find one voice. So how do you guys work? And I said, well, one of us writes a first draft, and then somebody else writes on top of that, and somebody else writes on top of that. And it keeps going round. And I said, Doug doesn't like conflict. So usually at some point, there's a lot of comment boxes with me arguing with Dirk saying, you can't say that. And he says, you can say that. And I'm saying, you can only say that in German civil law, which is silly. You can't say that in common law. And we go back and forth, have a big argument. And at the end of it all, we have this sort of paper. And Dan let out a long sort of sigh and said, oh, he said, writing on top of each other. He said, that requires letting go of a lot of control. And there's probably something in that for lawyers, I think. But we all are pretty much the way I used to be, which is very committed to our individual words, very committed to the clarity of our ideas. We want it to all be just right. It's sort of how we are trained. And, you know, now this stuff I do, we try to pitch everything at some universal level. You know, with a civilian lawyer and a common lawyer, we try to cover the field. And so you can't even really have it be all perfectly right. It's just throwing around big ideas about where things are going and how regulators should respond to that. So it's a very different way of working, but it seems to have a whole lot more impact. So to finish up, what I don't know. I think what I don't know is much more important than what we all know. The first big question, I suppose, is I've been working in poor countries for 8 years on financial inclusion. And the Gates Foundation is really behind this, the MasterCard Foundation, the United Nations Capital Development Fund. Lots of important players are around the push for financial inclusion in poor countries, and I still don't really know whether it's a good thing. The problem with financial inclusion is not providing payments mechanisms for poor people, that's good, but it also involves providing debt, access to debt for poor people, which is very much a two-edged sword. It's just really difficult to know what the net benefit of it is, particularly because there's so much spin. There's so many people like Gates, MasterCard and others that are very committed to this being a good thing. They throw so many resources at it that the dialogue, the conversation that comes up is that it's a good thing. My inner jury is still out on it. The other thing that was sobering recently was, I don't know if you probably didn't notice, but when the US pulled out of Afghanistan a couple of weeks ago, it came to light that they had left in there the biometric databases that identify who worked for the US government, who worked for the police, and who worked for the army. So now the Taliban can go around with face readers or iris readers and work out who their enemies are that they may wish to seek retribution upon. Would have been a good idea if the US had had some, blackout key or wipeout function or something built into its software database, but evidently they didn't. And it really made me think very deeply, because when we go in and advise countries on how do you get financial services support, we always start with digital identity. You have to start with digital identity. If you're in a country where people don't have driver's licenses, don't have passports, don't have paper identity, you've got to give them some sort of digital identity to get around the money laundering and terrorism financing problems of people accessing a financial system when you don't know who they are. They could be criminals. And the obvious way to give them that identity is biometrics, because in the absence of rigorous paper-based record-keeping systems, there isn't much else except biometrics. So I felt sort of relieved that I'd never done any work in Afghanistan, because I thought, well, at least any of the databases I'd recommended haven't been implemented in Afghanistan. But then I sent a couple of emails and found out, no, they had. We do work for the Alliance for Financial Inclusion. The Central Bank of Afghanistan is one of the members, and they had run with our ideas. So I take some comfort from the thought that this was just identifying regular people. It wasn't identifying their linkage to anything. The databases that could literally be life-threatening are the US government ones. But it still makes one think. You know, when we have designed these systems in the past, we have never considered, to be honest, the possibility of a total regime change with a very malicious, evil regime coming into power. So we need to think about that in the future. We can CDR in the next line in the slide is the consumer data right. And the question is, how will that play out in Australia? The consumer data right is the idea that people are in charge of their own data. And it will allow you, it allows you to transfer your banking data now to a different bank so they can make a better offer of services to you. It's in its very early phases, but it's intended to roll out right across the economy. It's incredibly transformative. Australians haven't worked it out, but it's huge. The potential is huge. It'll roll out next in energy and then in telecommunications, so mobile phones, after that in superannuation, in insurance, in other sectors. So I think Australia's economy is characterised by a low amount of competition, but CDR is really a potential answer to that, but I don't know how it's, I'm going to be fascinated to see how it's going to play out. It's really interesting that it's a government initiative because I wouldn't have expected that from our government, but we're getting it and it sort of looks good, but we'll see. The big thing I don't know is that everything I've been talking about is data, and all of data is based on consent. So the data about you is gathered when you tick the little box, do you consent, to Google knowing your location? And if you don't tick that box, by the way, you should try it sometime. Google doesn't work, right? You search for the local cafe and you get one in Boise, Idaho or somewhere because it doesn't know where you are. Most of you probably are aware, once you've ticked on that box on a lot of apps, it stays ticked. It's really hard to untick it. The app continues to send information about your movement to, the phone continues to send information about your movement to the app. Our data exhausts are really large now. It's all based on the idea of consent, but I was talking to Mark about this before we started. Consent works really well in buying apples and oranges. If I don't like the apples at my local fruit store, I can, get in my car, go down the hill to Woolworths and buy the apples there. If you're a young person, there is no alternative to your social media platform. If you don't consent, you can't communicate with your friends. My eldest daughter had a small job when she was in college at Melbourne University. She needed her Facebook account. That's how she was a sort of student activity coordinator, and all the coordination happened through Facebook. So it's no answer to say she consents or not consents. She either consented and had her part-time job or didn't consent and didn't. These things have become essential utilities. Consent is the wrong model, but I don't know what the right model is. Other things I don't know is why our lovely Prime Minister seems to be wanting to provoke a war with China, why the English ever voted for Boris Johnson and all sorts of things. But we won't get into that. So back to Mark, back to you. Questions?
Many thanks for us. That was a lovely presentation. Thanks for covering all of the detailed topics that you've talked about today. I just remind anyone that if they do have questions flowing, then please flag it in the chat. Although I don't mind if somebody doesn't ask any questions, because I've got plenty that I want to ask after the discussion. I want to kick you off with going back to consent, and it feels a bit wrong to pick on something that you've already said you don't know the answer to. And I may change the question a bit, actually, because I was going to ask you to think about, well, could you pick a consent-based mechanism that you've got now and provide us with a radical imaginary of what it could look like? But given that you said you're not sure about this, I think what may be a more interesting question is, how are you trying to reconceptualize consent? How do you think you might rethink what consent could look like over the next year or two?
The modest thing to do would be to have a series of levels of consent, like 4 predefined levels, and people get to consent to, the use of their data forever, or their use of their data for a specified limited time, or a use of their data for a specified purposes, and no other purposes, various things like that. I have 2 problems with consent. One is the one I've identified, which is that it is illusory. I think they've done studies, people don't read privacy policies. In America, they had that one company, startup, for some fun, put in the privacy policy that if you've read this far, send an email to this address, we'll send you a check, we'll send you $10,000. Nobody's ever claimed the money. In another one, a different company said, if you consent to using our product, you also agree to gift us your firstborn child. Nobody's ever objected to it. nobody reads privacy policies. So so that sort of is completely fictional. The other thing is whether people consent or not, I suspect, and I've been told by people in industry, once the data rather gets into the system, the extent of consent to its use sort of doesn't stay attached to it anyway. It all sort of disappears in this great sloshing thing of data. So it doesn't work up front and it doesn't work at the back end in the application of it. So I've got some really strong reasons to object to it, but how we come up with a better model, I'm simply, as you flagged, I'm simply not sure. It's my next big project for the next 12 months, is I want to write a series of 3 articles where we sort of start by analysing all the problems and then think about, I suspect we need to step outside the framework we're in and approach it all from an entirely different framework. I think that's probably it.
Which sort of leads me to another question now. I was going to ask you a question about regulatory sandboxing here, but what I might do is just change that slightly, given what you've talked about in your discussion. And picking up on what you've just said, Ross, about this idea of reimagining what we already have. You talked about in your discussion the real challenges about the fast-paced movement of life now. Can we take that back to legal education and think, what's now the role of law schools in teaching our law students about the dealing with the pace of this type of existence? Because I was really taken with some of the things that you've said about our precepts of the type of research that we should do and the type of teaching that we do with our law students. You know, that we privilege sole authored publications, even though they have a detrimental effect across the whole of the legal academy. How far do we take this idea of radical reimagination when it comes to law? And in particular, what do we now need to do in law schools, do you think, to be preparing our students for this new world?
It's a very good question. I mean, one of the things we need to do is, you know, we have this lovely structure in Australia, which I think works very well, of the dual degree, you know, straight out of high school, you know, BA LLB, BCom LLB. One thing we could do is try and get more students out of that bloody BCom stream into, you know, some other one, almost any other one. I think, personally, I think combining commerce with law, even though it's become the classic combination, is not a really good combination. You know, people are better off with arts and law. They'd be much better off with information science systems or computer science, or, you know, but I mean, the demand for lawyers who understand data is huge, but we're not really training them. And I inquired, you know, we've got a strong computer science school at UNSW. We've got a Bachelor of Computer Science, Bachelor of Law degree. I inquired last year how many students we had in it. 2. We had 2 enroll in it. You know, it's the one combination we need more than anything. But the other thing I think is, I think as legal academics, we need to take more risks. I suppose you'd say, of course he'd say that. But intellectually, I think if what we're doing is the traditional stuff, which is interpreting the latest High Court decision, or in, you know, chewing off something fairly small like that, it's pretty safe. But the big firms can probably do it better. You know, why should we be doing something that Mallisons or Allens or Klutz can do better or as well? And they all do that stuff. And it doesn't, you don't need to be you just need to be a bright young, you know, second-year associate in a firm to write the thing that analyses the latest High Court decision. You don't really need the privileges of a scholar of time and distance and whatever. So I think we'd be much better off if we were thinking bigger of, you know, what are the real sorts of challenges? Where should the law, you know, where does the law really need to step up? And, you know, some of these big issues around, you know, data and privacy, and, you know, I know at UNSW we've got about 100 academics and about 30 of them identify as working in technology law now. And, you know, and I think there's really good reason for that, which is that this technology and data is what is stretching the legal system more than anything else, and that will continue. You know, the system is so far behind. Really, you know, and it needs scholars to tackle those sorts of things. You know, one of the things I've been struck by is the sponsorship of my position by Mallesons and KPMG. It took me a couple of years to work out what the purpose was, but the purpose really is that I can say the things they can't say. I can say the sort of provocative. So when we do stuff for clients, I am the person on the stage to say the provocative things that challenge the clients, because the partners largely agree with me, I think. They can't say it because they've got to be the trusted pairs of hands to implement the transactions. They can't risk scaring the clients off. You know, if I say something that the client gets really scared by, they can just say, oh, well, yes, yeah, he's an academic, you know, and yeah, we contribute some money to the university, but that's not us. You know, if I say something the clients like, then they put their arm around me metaphorically, but if I don't, they can push me aside. I think that's a better role for scholars, to sort of be out there challenging and waving big red flags about the way that the legal system is not coping. I understand, though, that there are real institutional impediments, because for individuals who want to get promoted up our greasy pole, sometimes selecting small, discrete topics and doing them well might be safer. That's an individual sort of choice, I think. But I think as scholars, we have an enormous opportunity, and it sort of behooves us to grab it and take some risks.
So I just want to get to two more questions, and we'll leave the final question. We'll end on a positive note. We'll talk about generosity. The one but last question I want to ask sort of links to that notion of risk. And I just want to step you back to what I was going to talk about, which is regulatory sandboxing. Because there's an issue that's not covered at all in the law schools,
no,
as far as I know. But it seems to be that this is a space that's developing quickly, where there is a huge demand, a rapid demand that's burgeoning. What could we do in law schools to promote the type of more risky teaching around, say, regulatory sandboxing, that would help our Australian law students to be more accustomed to what's going to be coming next? Is there anything that we can do in terms of teaching, not just in research, as taking risks in spaces like this?
I think one thing that I'm struck by is how conventional, in terms of their career, thinking about their careers, a lot of our students still are. You know, I think I have discussions with students quite often, and they seem to assume that the most money they can make in their future is working for one of the big 5 national law firms, which is not the case. That if by staying on the straight and narrow, they're going to have the sort of greatest opportunities. I mean, they have got, in Australia, we channel some of our best and brightest into law schools. I question whether that's smart as a national policy, but it's what it is. So given it's what it is, I think one of the things we need to encourage them to do is to think bigger than just being servants of the corporate world in a law firm. You know, I think there's a lot of roles in startups, in tech companies, in all of these extraordinary companies that are firing up now that can use a lot of their skills. And, you know, I think, again, the dual degree structure means a lot of them are diversely qualified. It's fine if they want to go off and work for a law firm for a couple of years, but after that, I always encourage them to look much more broadly afield, because I think, you know, one of the senior partners at one of the firms I'm with recently reflected on the fact that he, looking back over his own career, he realised the very smartest people he knew had stayed in the firm. The people who'd gone on to have the biggest careers, have the most autonomy, seemingly the most fun, and make the most money, were the ones who hadn't made the cut in the firm and therefore had been forced out into other avenues where they had found they were far more competitive than the people who were already in those avenues and had gone on to have very big careers. I think there's a real lesson for our students in that. You know, I think all of us could be a whole lot more adventurous, I think. in how we sort of think about things.
Which leads us very nicely into the last question with 2 minutes to go. Generosity was a real strong theme that came out through your discussion. Generosity both to colleagues, but also generosity of spirit, of having a really broad sense of being an intellectual as part of the academy. You mentioned in your talk good deeds. Could I get you to reflect on what good deeds you didn't do previously that you would do now?
That's a tough question, Mark.
It is. It's a hard one to finish off with.
I don't know, really. I mean, I've always been very motivated to help people in my little discipline or sort of sub-discipline around the world. I think that's a big part of it. I don't know if I have many regrets in that regard at all. What I do have is what I was very lucky with very early in my career. I remember I was teaching at Bond University on the Gold Coast, and a professor who's now passed away visited us from George Washington, a guy called Andy Spanogle. And I'd written a draft I'd only been an academic for about 3 years, and I'd written this draft of this article. He read it really carefully, and he had some really good suggestions for how to alter it and make it appeal to a US audience, which I'd never thought of it as for a US audience. It was quite beyond my experience at the time to reconceive it in that way, but he did the work for me on it. And we sat up until about 1 o'clock one morning discussing it. And towards the end of it, he was with Bond for 3 months. Towards the end, I thanked him for it so much. And he refused to let me thank him. He said that was his job. And I pushed him on it. He was an international business transaction scholar. And he said, well, we've got 4 international business transaction scholars at George Washington. I'm the most senior of them by far. He said, the other 3, at least 2 of the other 3 are already better than me, probably. And in time, all of the other 3 will be better than I am at doing this. And that means I have succeeded. And that was really formative. That was this is the plus side of America, this extraordinary generosity. That's sort of what he saw his role as a senior academic being, making sure that the people coming after him were better than he was. And I think if you picked up a sense of generosity in the presentation, a lot of it is probably attributable back to Andy and to another mentor I've had, a fellow called Joe Norton, who thankfully is still with us, who's at SMU in Dallas. And Joe was incredibly important in my career for 15 years before I ever met him in person. We'd never met in person, but he was just incredibly important to me, and he has been to so many people's careers in my area. So I think that's one of the most attractive aspects of the academy, that sort of intergenerational support that comes about because we're all committed to something bigger than ourselves.
Well, thanks very much for being generous and sharing your time today, Ross.
It really was my pleasure. Thank you for the invitation.